Welcome to Call to the Bar, International Law Over Drinks, a series of informal conversations about current issues in international law, life in academia, and whatever else is on our mind. In these conversations, we're speaking off the cuff and without the benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. I'm Dr. Ntina Tzouvala. I work at UNSW Sydney as an associate professor, and today I'm joined by Professor Tonia Novitz, who is a professor of labor law at the University of Bristol Law School in the UK. She's currently the UK representative, a UK representative on the advisory board of International Lawyers Assisting Workers and a vice president of the UK Institute of Employment Rights. She was a founding co-director of the Bristol Centre for Law at Work. Her research interests encompass labour rights, international and EU trade law, sustainability, and migration. She's the author of International and European Protection of the Right to Strike. She's a co-author of The Right to Strike in International Law, and she's a co-editor of the recently published The Right to Strike Reimagined, which came out from Heart this year. She was also, and that's the most relevant to this case, a pro bono member of the legal team advising the International Trade Union Confederation on the litigation that took place in front of the International Court of Justice concerning the right to strike. Indeed, as we are recording this episode, the court's advisory opinion has only been released a few weeks ago, and Tonia is joining us today to discuss it with me. Before we start, I have to ask your customary question, Tonia, which is, what is your drink of choice?
Right. Well, I would like to toast this advisory opinion with a customary glass of something bubbly, but it's 11:30 in the morning here. So I am here with my standard cup of coffee, which is a flat white from a great coffee shop close to the University of Bristol. Called Under Pressure, if anybody ever makes it to Bristol. Really good coffee shop.
Okay, that sounds good. And I have to say, yes, I'm also keeping things quite non-alcoholic. I'm having a cup of ginger tea, even though it is much later in Australia, but I have to teach tomorrow morning, so I have to be sensible. Alrighty. So you are a first-time guest of the podcast, and there's a question that we ask to first-timers, which is how you find yourself working on international law, right? And I'm particularly interested because I understand that, your professional intellectual identity is much more closer to labor or employment lawyer, primarily at least, rather than international lawyer as such. So how did you find yourself working on matters of international law?
Yeah, so I certainly studied international law in my undergraduate degree and then on my master's. But it's true, my passion has really been labor law. And labor law is just a fascinating hybrid subject. So it brings together labor relations and political theory, contract tort, public law, human rights law, inevitably some international law as well. And I wanted to practice labor law, and I started to do so after law school. But my foray into practice coincided with the adoption of the New Zealand Employment Contracts Act of 1991. So that radically individualized bargaining in New Zealand. And, at that time I was just qualifying and I felt like a cog in a wheel. And so I wanted to do things that would be policy related, that would critique the law, which would explain why it's problematic. And that led me to apply for scholarships, got me first to Oxford as a student, and then Bristol, which gave me my first and so far only academic job. And I've just stayed here doing that. So my doctorate examined protection of the right to strike under international law, my master's having looked at political strikes. And I started visiting the ILO back in 1995. So it's been a really long journey to get to this point. where I can celebrate the great weight given by the International Court of Justice to the findings of ILO supervisory bodies on the right to strike. But, I'm really delighted to do so. So good journey along the way.
That's fabulous. That's such an interesting, journey to international law. So, as I said earlier, in May 2026, the International Court of Justice delivered its much anticipated, especially amongst labor lawyers and I would say labor activists,
Mm.
advisory opinion on the right to strike. And the question that had been addressed to the court read as follows, and I'm quoting, is the right to strike of workers and their organizations protected under the freedom of association and protection of the right to organize convention, which is the ILO Convention number 87 of 1948. And as you have, I'm sure, understood from Tonia's comments, the court answered this question in the affirmative. And we will get to the ICJ and its reasoning. But before we get to that, I thought it might be particularly helpful for our listeners, especially those who are not international labor lawyers, if you could tell us a little bit about the International Labor Organization and especially the fact that it's a pretty unique international organization because it has this very peculiar tripartite structure.
Yeah. So I don't want to bore your listeners, so do get me to stop if I go on for too long. So the International Labour Organization is a very unusual United Nations agency. It became the first UN agency in 1945, but it was actually established in 1919 in Part 13 of the Treaty of Versailles. So it is more than a century old. And its rallying cry in the preamble to Part 13 of the Versailles Treaty was social justice, peace and social justice. And the first general principle in Section 2 was that labour should not be regarded merely as a commodity or article of commerce. Now, at that time, the idea of permanent international global organizations was pretty new. And the drafters of the constitution for the ILO were really experimenting with the form of international organizations in an interesting way. So what they wanted was a kind of tripartite structure which would enable connection with the social concerns of organized labor and the commercial interests of employers, as well as the vested interests of states. And the idea was that if you connected to both organized labor and employers, this would, to some extent, operate as an enabling device for the ILO, that they could make better policy, but also this was going to be a constraint because it would require compromise. So the very first ILO Director General, Albert Thomas, said that tripartism was needed to make the ILO effective because it was offering the smoke and dust of practical politics, I'm quoting here, which may get things smudged but gets them done. So that was the idea. Now, representation of worker and employer interests in an international organization really required constitutional protection of freedom of association. So that was absolutely fundamental from the beginning to the constitution of the ILO. And that was followed up later by a Declaration of Philadelphia, which was much more concerned, I think, with also the broader protection of labor rights as human rights. So freedom of assembly as well as association. And then we have a Declaration on Fundamental Principles and Rights at Work, which comes in 1998, which again stresses how important freedom of association is, as well as effective protection of the right to collective bargaining. So you've got freedom of association woven in there. And now the ILO itself is made up of three main bodies. There is the International Labour Conference, which basically debates and adopts standards by a 2/3 majority. And that's tripartite in the sense that every state delegation has two government representatives, one worker, and one employer delegate that can vote. So states are still pretty much in charge, but there is parity of treatment of these two non-governmental species of representatives. And conventions like Convention 87 have to be adopted by a two-thirds majority. So you really need to get either the
Either the
employers or the
employer.
workers on board, but preferably both in order for it to be adopted. And there are very accurate records of debates, records of proceedings, so you can see exactly who argued what and where. It's very transparent. Then there's a governing body, which is an executive body of the ILO. It has the same kind of representative structure. So 56 members, 28 represent governments, 14 represent employers, 14 represent workers, and it does the kind of agenda setting for the ILC. It manages the International Labour Organization supervisory system as well. So it has set up a governing body committee on freedom of association, which hears complaints and responds to those. And it was the governing body that, by a majority, referred the right to strike dispute to the International Court of Justice. The Director General just signed that off, but it was the governing body that did that. And then you have the International Labour Office, which is the secretariat of the organisation. And what it does is does all the paperwork facilitating the preparation of the reports for the International Labour Conference. So in the advisory opinion, you see reference to surveys that were conducted by the International Labour Office. It is headed by the Director General, who is elected by the governing body. So again, workers and employers get a say in who is the Director General. And within that tripartite structure, within the International Labour Office, there's a Bureau for Employers' Activities, which is called ACTIMP, or known as that, and a Bureau for Workers' Activities called ACTRAV. But they are really part of the larger International Labour Office. What is really important, I think, to stress at this point is the role of the International Organization of Employers, the IOE, and the International Trade Union Confederation, the ITUC, who were very active participants in this litigation before the World Court. So the International Organization of Employers essentially acts as the representative for the employers group at the ILO. So it represents the employer representatives. And the International Trade Union Confederation provides that parallel support for the ILO workers group. So both the IOE and the ITUC have functions outside the ILO, but they come in and they act as a kind of trade union, if you like, a sort of organization that supports the IOE, the employers, and the ITUC, the workers group. And so they were heavily involved in the discussions that preceded the governing body debates about whether to refer this to the ILO. So the ITUC and the IOE are key actors in some ways within this dispute.
Awesome. That was very helpful, right? Especially because, yeah, as you explained, this is such a different structure in which, of course, states still have much control as a representation, but usually we know international organizations to be predominated by states, right? And I think that's a useful prelude to understanding the dispute or the disagreement that led here, because unlike other interpretative disagreements about international law, it wasn't simply a disagreement between states. It
No.
was fundamentally a disagreement between employers' representatives and the representatives of workers, right? And just to then understand the second point, which is, can you tell us a little bit about the relevant treaty, right? Convention number 87 of 1948. You said before that in a sense, the right to collective representation is inherent in the idea of the ILO, right? Because how could this work without having mechanisms? But what were the specific protections that Convention number 87 brought to the table?
Yeah, so there were discussions about creating specific conventions or recommendations on collective bargaining before the Second World War, but for various reasons, state practice hadn't fully aligned at that point, and the ILO came under considerable stress in the 1930s, as you would expect. So certain things that had been anticipated just didn't materialize. So in the wake of the Second World War, the American Federation of Labor made a request to the new United Nations Economic and Social Council, ECOSOC, that the International Labour Organization take into early consideration the problem of trade union rights with reference to certain questions, and they included to what extent are labour or trade union organisations free to deal with employers of workers they represent and conclude collective agreements and participate in their formulation, but also to what extent is the right of workers and of their organisations to resort to strikes recognised and protected. Now, the World Federation of Trade Unions also made a comparable request, but just wanted direct action from ECOSOC, and ECOSOC transferred those bundle of questions to the ILO. So once ECOSOC made that referral, the ILO governing body really got into action because they didn't want this decided at the UN. They wanted the ILO to be a functioning entity, so they were really keen to adopt conventions as soon as possible. Convention number 87 is adopted in 1948. So, it's a very swift turnaround. And what the ILO Secretariat did, the International Labour Office did, is it surveyed the member states' labour legislation and suggested two ways to go on freedom of association. They said we could provide a detailed list of concrete guarantees, or we could put certain general overarching principles into a convention or conventions. And in the end, they went for the overarching principles approach, and they created a draft ILO Convention number 87. And they also created a subsequent convention, Convention number 98, which would address right to organize and collective bargaining. And both 87 and 98 are designated now as fundamental conventions of the ILO. They're part of a core of 10 conventions which parties are expected to ratify. Convention number 87 has now been ratified by 158 countries. There is one convention, the Worst Forms of Child Labour Convention of 1999, Convention 182, that's been ratified by all ILO members. And the least ratified fundamental convention is Convention 187, which is on a framework for occupational safety and health, with 75 ratifications, but that's just recently been made a fundamental convention. So what has happened is that Convention 87 was really setting out basic fundamental principles on freedom of association and the right to organize. It's for a very long period of time been regarded by ILO supervisory bodies as entailing a right to strike. There are two key supervisory bodies here. One is a committee of experts on the application of conventions and recommendations. It's an expert committee. It responds to state reports, to representations from governments and workers, and tries to apply convention standards to what is happening inside states. And it applies ILO Convention 87, and in that context found that it couldn't do anything other than comment on the right to strike and try to appreciate what standards should apply relating to the right to strike. The Committee on Freedom of Association, as I said earlier, is a governing body committee, hears complaints, could refer this on to a conciliation commission on freedom of association, but tends to actually deal with that in-house, and the governing body makes recommendations. And again, when trying to look at freedom of association, that committee found that it could find a right to strike that's derived from freedom of association in the Constitution, as well as from ILO Convention 87. So Convention number 87 does not refer expressly to the right to strike. Instead, what the ILO supervisory bodies have done is they've looked at Articles 3 and 10, and they have found that strikes are encompassed in Article 3 of the Convention, which says that workers' organisations have the right to organise their own activities. And it's been assumed that strikes are activities and that they have the right to organise these. Also, Article 10 talks about what a workers' organisation or an employers' organisation might be, and it says that workers' organisations for this purpose are those organisations that are there for furthering and defending the interests of workers. So it's been assumed that the ordinary meaning of these provisions means that workers' organisations are entitled to organise their activities to further and defend workers' interests. And because without a right to strike, you have an inherent imbalance of bargaining power between workers and employers, it's really hard to see how the right to strike could be excluded from Convention 87 activities. So
yes, basically
that's the
something
background.
that says, what's the point of collective bargaining if you can't strike, right? Like, presumably, imagine the argument at a certain level was the convention was drafted in this world, in which like the right to strike is a fundamental like bargaining chip of workers in the process of collective bargaining, right? Workers have very little else available if collective bargaining is not going anywhere.
Absolutely. I mean, what we say is that without the right to strike, collective bargaining would amount to collective begging. And that's been something that's been said, from the 1920s onwards in literature across the US and, spread everywhere. So that's definitely the case. I mean, I think there's one other point, though, to make about Convention 87 is that it isn't just about collective bargaining. So what we would say, I think, in the trade union movement is that it's legitimate to use strikes, not just in the context of collective bargaining, but sometimes, for example, in protest in response to government policies which have direct impacts on workers and their organisations. So where social security is
affected. About pensions, I was going to say it's a classic.
Absolutely. Yeah. So what is important, I think, about placing the right to strike under Convention 87, primarily rather than Convention number 98, it isn't just about collective bargaining. It's about collective bargaining plus, if you like.
Yes, collective action more than collective bargaining. Fantastic. Thank you. So I think you have really laid it out really nice for us. But before we go to advisor opinion, I have one final question, which is, how did things end up so contentious in the ILO that we ended up in the ICJ, right? Because as you've set out so nicely answering my first question, the whole idea behind the ILO was to have this like collaborationist model, right? Which is why, for example, initially in the interwar period, the most radical parts of the union movement were quite skeptical towards the ILO. How did things break down so much that an interpretative question ended up in front of the ICJ?
Yeah, so initially, when the International Labour Organization came into being, a series of interpretive questions were asked of the Permanent Court of International Justice, and that made sense because it was a new system and there were all sorts of issues and references. But then things calmed down, and this is the first reference in a very long time, almost a century. So since 1932, I think. So it's definitely an interesting story. I think that we have to recognize that the ILO was intended as a kind of compromise to ensure forms of social justice that would preempt radical socialist government. So in 1919, you're in the wake of the Bolshevik Revolution in Russia. Employers have an interest in collaborating at the ILO and being part of that process in establishing peace. And you certainly don't want those who've been engaged in the armed services coming back from war, not having jobs or not experiencing justice at work. It could be revolutionary. So that makes a difference. And then again, the same thing, I think, in the wake of the Second World War. But in addition, you have the process of the Cold War. And the ILO, wins a Nobel Peace Prize, is heavily involved in trying to forge maybe a debating chamber between the two sides during the Cold War. And employers are prepared to make compromises. They are actually, in that period, some of the most adamant advocates of a right to strike in Poland. They are very keen. And what they want is to participate fully in standard setting. And I think it's important to realize that although the Committee of Experts, which is found on the right to strike under Convention 87, is an expert body, employers were involved with government and worker representatives in the governing body Committee on Freedom of Association, and arrived at the jurisprudence there on the right to strike by unanimous decisions. So they were fully part of this process. But what started to break down that consensus was probably the end of the Cold War, the end of history, as Fukuyama says, and this idea that capitalism has prevailed and the balance of power changes. So there are various odd statements from the employers group at different times, from the mid-90s onwards, but there is never any doubt that the right to strike is covered by Convention 87. There is more resistance to the principles that have been arrived at by the supervisory bodies, a thought that perhaps they're too broad. And what the employers group keeps doing at this time is to try to put dispute settlement on the agenda in the conference. And it keeps being blocked by the governing body that thinks that the existing system is fine, we all agree with it. There are already significant limitations on the right to strike, which have been arrived at by tripartite, I think. So, for example, strikes are not to be taken by public servants exercising authority in the name of the state, not in essential services, when you'd have endangerment of life, personal safety, not in acute national emergencies. And there are accepted limitations, procedural limitations, substantive limitations on aims. So the jurisprudence is very developed. And the majority of the ILO, the governments and the workers, keep blocking the employers when they try to put dispute settlement on the agenda. And this erupts in a kind of frustration in 2012. So normally, findings from the Committee of Experts go to the Conference Committee on the Application of Standards, which is tripartite, and then on to the International Labour Conference, which can condemn state actions with a special paragraph or maybe certain other measures for Myanmar, Burma, for instance. But in 2012, you have the IOE at that stage representing the employers and saying that from then onwards, they will refuse to deal with any case relating to the right to strike. And they have various reasons for this. They say that the Committee of Experts has no authority to interpret Convention 87 to include a right to strike. So it's about the interpretive competence of the Committee of Experts. Mustn't be interpretive, can only apply but not interpret, which is a very difficult thing to do in practice. How do you apply a standard without interpreting it?
Yes, applying something without interpreting it is, I think,
almost impossible.
Possible, yeah.
And more than that, it's a very odd thing to say because the employers group had been heavily involved in the Committee on Freedom of Association jurisprudence, which was completely aligned with that of the Committee of Experts. So it was an odd thing to challenge one institution, but not another. They then said that Convention 87 couldn't be legitimately interpreted to include a right to strike because it wasn't expressed in that convention. And that was really problematic as a claim because obviously there are so many international instruments and domestic constitutional conventions where there is reference to freedom of association or collective bargaining, And the courts of or supervisory bodies have found that that entails a right to strike. So, European Court of Human Rights under Article 11, the Human Rights Committee under Article 22 of the International Covenant on Civil and Political Rights. So that was a fundamental challenge, not just to Convention 87 and its interpretation, but what is happening in constitutional litigation in Canada or before the European Court of Human Rights or even the European Court of Justice. So it was a huge shift and created real concern amongst the workers' group. And also, the employers said alongside this that they thought the right to strike had been interpreted and applied in too generous and broad ways, and they wanted to restrict its scope. So from 2012 onwards, the employers' walkout from the CAS, their own personal strike, has meant that they will not consider as employers any case that relates to the right to strike. So that meant that for a good decade before this referral to the International Court of Justice, it was not possible for the International Labour Conference to condemn any blatant breach of the right to strike, imprisonment of strikers, torture, anything relating to that could not go to the International Labour Conference, which is fairly brutal given what was happening in particular states. So those right to strike cases have gone to the Committee on Freedom of Association as complaints, and the governing body has made recommendations on the right to strike. But what was happening in the last 5 or 6 years before the reference is that the employers group was becoming increasingly recalcitrant, was not following on from what the CFA had said in the past and was trying to be obstructive. So there was a huge frustration. And there was an optimism, I think, that it was worthwhile pursuing protection of freedom of association and the right to strike in the ILO in November 2023. Biden was still in the White House. He was funding various ILO freedom of association projects relating to the right to strike. Governments were on board for referring this. It was a moment when the workers' group was clear that they had reached the point of frustration, and allowing the employers to continue could seriously undermine the right to strike, both at the ILO and under other international human rights instruments. So something had to be done. And the workers' group, as I was saying, is closely allied to the International Trade Union Confederation, which also had those broader interests in the right to strike as a human right. So it was agreed by a majority in the governing body that there would be a reference to the ICJ. There was debate over the question to be asked, and it was decided, I'll come back to this, that it wouldn't be a question about the competence of the committee of experts or about the content of their judgments, just simply whether the right to strike was covered by Convention 87. A simple legal question. Now, I think that some of the governments who voted in the governing body for reference to the International Court of Justice did not want a positive finding from the advisory opinion. So the UK was one of those that voted for reference to the ICJ, and this was Rishi Sunak's Conservative government clearly hoping the reference would fail. It was a high-risk strategy because if it did fail, it would have massive implications. But I think the point of frustration had been reached that it had to be done.
Excellent. That was so interesting, including I didn't know that there was such a long history of employers supporting the right and then changing their minds, which makes a lot of sense. The chronology you're giving us, of course, makes sense. And it's a matter of like, yes, like relative power and relative confidence. But yeah, I didn't know. And I imagine also that must have made the interpretative work a little bit easier for the side that supported the existence of the right. On which point, as you said, let's finally get to what the court actually said, which is, as you said, we are dealing with the treaty text that doesn't actually explicitly mention the right to strike, right? And the argument put forward by employers was actually a typical interpretation argument, which is if a provision mentions a number of things and it omits others, we should assume that the omission is intentional, right?
Yeah.
That was one of the basic arguments. The court rejected this reasoning, and I would say also to the listeners who are interested in treaty interpretation or are teaching treaty interpretation, it is really a textbook lesson in treaty interpretation, right? Whether one agrees or disagrees, they really go through the steps of the Vienna Convention one by one, including a very long discussion of what counts as subsequent practice and what
Yeah.
sort of subsequent practice, because they wanted to see how much weight they should give to the ILO organs. So could you just walk us through the reasoning of the court? How did it nevertheless conclude that there is such a right, even though it's not protected explicitly?
Okay, I will. I have the advisory opinion here, so I can wade through it. But I mean, I wonder if maybe the first thing to say, and please interrupt me if I go on for too long about something, or you would like me to elaborate on something a little bit further, please just say. So I think the first thing that the advisory opinion does is says, well, they have jurisdiction, but beyond that, they're invited to widen the question that was asked of the court, and it might be worth just saying something briefly about that. So the employers wanted the court to address a further question. They wanted the court to allow consideration of the content of the right to strike, its limits or the conditions of its exercise, and make it possible to ascertain which authority has the competence to determine the scope and content of the right to strike. So they're basically saying, we want to challenge the jurisprudence of the supervisory bodies and the ILO, and we want you to tell us that they're not competent to decide that scope and content. And the reason that this had been debated in the governing body, but the governing body had decided not to ask that second question, was really because we realized that the court could never just wholly endorse the findings of another supervisory body. They would always reserve the right to say that something was an inappropriate interpretation. So we knew that we couldn't win if we said rubber stamp the committee of experts, because they would not be able to do that, and perhaps neither should they do so. But also I think the employers wanted to dilute the question and lead the court down some tricky paths in terms of content and scope and what's appropriate. And the International Court of Justice unanimously refused to be led down that track and said that the question itself, whether the right to strike is protected under Convention 87, is clear, unambiguous, and they will just go ahead with that. So I think that in the end, the fact that this is just a very limited reference it will have repercussions, because there will be debates on the scope and content of the right to strike later. But I think that these judges in the World Court are not labour lawyers, and you can see that in some of the dissenting opinions, and asking them to decide on particular facets of tripartite supervisory findings without background knowledge would lead to some really strange results. So I think in the end, and we'll come to this in a moment, but the majority advisory opinion by 10-4 comes really close to endorsing what the committee of experts does. So Judge Tomka, in his dissenting opinion, this is at paragraph 82, says, the court appears to have implicitly answered a question that was never put to it, whether the committee of experts is competent to determine that a right to strike derives from Convention 87. And he meant that as a criticism, but actually it's a reassurance that the committee of experts can go ahead, is no longer under pressure to change its practices because a right to strike arises under Convention 87. So I should go on to talk about how we get there. And you're right, it is like a textbook unraveling of Articles 31 and 32. So looking at the Vienna Convention on the Law of Treaties and starting with Article 31, Paragraph 1, regarding ordinary meaning and purpose, that mapped on perfectly to the submissions of the ITUC, the International Trade Union Confederation, and other sympathetic submissions. So we argued that finding that there was a right to strike fitted with the ordinary meaning of Articles 3 and 10, as I said before, and also we can assume there was no intention to exclude the right to strike given express inclusions in Article 8 regarding the law of the land and Article 9 on police and armed forces. The advisory opinion doesn't mention Article 8, Paragraph 2, which says that there is an exclusion where the law of the land restricts the right to strike, but also says that the law of the land should not be such as to frustrate the objectives of the convention. So there is scope for evaluation of the law of the land in there as well. This principle that a failure to expressly include should not necessarily be assumed to mean exclusion does actually come in when we look at past ICJ jurisprudence. In particular, a really old reference to the prior Permanent Court of International Justice in relation to agricultural workers. So that was a case that concerned whether the fact that the word agriculture was not explicitly mentioned in the Treaty of Versailles meant that you could not adopt conventions relating to agricultural workers. And the court said that there was no real ambiguity. The court had no doubt that agricultural labour could be included in the reference to labour under the Treaty of Versailles and fell within the competence of the International Labour Organization. And they also, and I think this is interesting, that the Permanent Court of International Justice then relied on the fact that the subject of agriculture had been repeatedly discussed at the ILO for the few years after the creation of the ILO, and no one had suggested that this was outside the remit of the ILO, and so they were in a sense responding to the practice in the ILO and the assumptions. So there's a kind of parallel with this case in that sense. The most significant statement of the court for me comes at paragraph 73, where the advisory opinion says strike action is one of the main activities engaged in and tools used by workers and their organizations to promote their interests and improve conditions of labor, thereby ensuring the effective exercise of the freedom of association protected under Convention number 87. And I think you can see that that is a very strong statement that could be used in litigation internationally and within various international and industrial labour frameworks. There's also a declaration of the Vice President Subotindi where he basically says the same thing, but talks about the power imbalance between labour and employers, and says that it is necessary to withdraw labour to exert pressure on employers and to address this fundamental power imbalance. So I think those two things are really useful in terms of a contextual understanding of why the right to strike is important to freedom of association and organisation. It's interesting, I think, under Article 31, paragraph 3b, when there's a discussion of subsequent practice. I think you were saying you might be interested in this. I'm not sure whether it was this or paragraph C, but we'll come back to it. There is a really interesting analysis of whether the interpretive findings of the ILO supervisory bodies can amount to subsequent practice. Firstly, under Article 31, paragraph 3b, where you would have to consider whether the findings of the ILO supervisory bodies, but more importantly, the response of state parties to those, was so overwhelming in terms of consensus that you could regard this as, I suppose, a basis for finding that Convention 87 encompasses the right to strike. And then there's also a discussion, and this is at paragraph 77, about the different standard that can be applied to this kind of subsequent practice under Article 32, where subsequent practice can serve as a supplementary means of interpretation, but doesn't require this entire common understanding of all the parties regarding a certain interpretation. I understand that's been controversial for international lawyers in two ways, that it gives perhaps a second bite of the cherry. You can, if you don't make the threshold under Article 31(3)(b), you have this chance later under Article 32. I think that Article 31, paragraph 3b sets a very high threshold. So what is very clear is that whenever you have international standards, you will have certain parties who disobey them. That's why we have supervisory machinery. And I think it's pointed out in some of the declarations that it is quite unusual, relatively rare and anomalous for states to actually question the supervisory findings and the supervisory principles. Sometimes states will say, we are not in breach, but we do accept that a right to strike arises under Convention 87. It's just that we don't think we've breached it here. So it's very rare. And I think, it was really only 4 states who turned up to the International Court of Justice claiming that, and gave submissions claiming that a right to strike was not covered by Convention 87. But it's so interesting for me under international law that those 4 states and their adamant assertions means that it's very difficult to squeeze that within Article 31, paragraph 3b. And I think that's why Article 32 is important in terms of subsequent practice, to give some weight at least to the supervisory body's findings, but also I think their widespread acceptance within the ILO and the government, and in terms of government support for them. So I don't know if you want to ask anything on that, or whether I should go on.
No, that's more than enough.
Yeah.
I was interested, especially given the history that you laid out for us before, that it wasn't picked up more by the ICJ, that the employers only changed their mind like 50 years into the existence of the convention. They didn't seem to pay too much attention to that.
Yeah, I mean, I think it is there in some of the separate
Yes.
opinions and declarations, but yeah, it is interesting that it's not picked up on more. I also wonder, and a group of us were advocating that there should be a reference to the ICJ as early as 2014. We, with under the leadership of the ITUC then legal advisor Jeffrey Vogt, a group of us drafted this huge 122-page opinion that's still posted on the web, and we said it should go to the International Court of Justice as soon as possible, because this was a huge reversal from the employers at that stage. But I guess they had 10 years of trying to embed that into practice. It was
Right.
left to go on for 10 years. So by that stage, maybe it was harder to say
There
that.
was no disagreement. Yeah. I just
Yeah,
think it would still raise issues of good faith and all these things. But that's
I think it does.
yeah, it does. Especially
Mm.
if you have 50 years of ascending to the existence. Okay, so one thing that I'm really interested is just to take it outside of, the technicalities of trade interpretation, right? Especially because you yourself have such a long history of working with trade unions both in the UK and internationally. And I can understand the importance of the case doctrinally, but my question is, what is your, realistic appraisal of it? Is it going to help workers and their representatives? And I can think of 2 possible skeptical arguments. One is Great opinion, but probably, as you say, 10 years too late, because no fewer and fewer states seem to care at all about any aspect of international law, even like much more, supposedly fundamental aspects of international law. So that would be my first, like, how does this opinion come in this current political moment? And the
Hmm.
current bit is something you raised earlier, which the employers tried to raise, but I think there is points to it, which is, oh, the devil is always in the detail, isn't it? Like we can affirm the existence of a right to strike, but then if you overburden it with all sort of procedural requirements, if you exempt more and more workers from it, if you like, if you call everything a national security issue and then you stop everyone from striking, a theoretical right to strike is not helpful to anyone. So that's my sort of like legal realist skepticism, which is like an abstract right to strike doesn't really help. Why am I wrong to be so skeptical? Am I wrong
Okay.
to be so
And
skeptical?
no, I mean, you're not wrong to be skeptical. I mean, we know that, the real politics is always going to be important. So, first, what is happening within the International Labour Organization and the UN more generally at the moment? So, this is a significant statement that really challenges the employers group at the ILO. They were opposed in the governing body to referring this to the International Court of Justice. They will have to modify their position on the inclusion of a right to strike under Convention 87. But what is so interesting for me is the relative silence of the ILO on this issue. So I have received information from staff at the ILO that they have been told not to comment on this, that when you look at the ILO website and you see the page which deals with this dispute, there is the information there that it's been resolved, but no statement from the Director General
Oh, wow.
on the outcome at all.
Someone is spooked. Yeah.
So there is, there is a concern at the ILO, I think a twofold concern. One is if you want to keep the ILO going, you cannot wholly alienate the employers group. You've got to find a way of working with them on the back of this judgment. And the only official statement I have seen is that this will be discussed not at the International Labour Conference, but at the governing body in November. And that is possibly to ensure that that doesn't endanger the current instruments before the conference. For example, the planned convention and recommendation on decent work in the platform economy. So it's going to be interesting to see how that gets played out. And I really need to have a look at what's been said and done at the International Labour Conference, which is on at the moment, finishes on the 12th of June, before I can get a sense of how this is played out politically. So there is a sensitive position of the fact that it's a tripartite organization. Now having got this advisory opinion, there will be questions around whether it is binding. The position of the International Labour Office legal advisors was initially that it is legally binding, and that was said in the ILO written statement to the ICJ. And certainly this would be binding on any subsequent tribunal set up under Article 37(2) of the Constitution. So whether it's legally binding or not, it's pretty binding. What gets done with it will be interesting. Perhaps it will just be a quiet acceptance that the Committee of Experts can go ahead, and maybe the Conference Committee on Application of Standards will hear cases on the right to strike this year, which would be interesting. So we'll see what comes out. But the other second factor is obviously the US administration. So we've had the shift from Biden to Trump. The Trump administration withheld funding from the ILO for a period of time. All the Biden Freedom of Association projects were cancelled. There have been significant retrenchments, as I understand it, And I am not sure how activist the ILO can afford to be when Trump is supporting the employers group and
And
best global
literally
business.
afford in the most literal sense of the word.
Yeah. So
Yeah.
there are existential problems here for the ILO. I think that there is possibly going to be more use of this advisory opinion because they're so closely interrelated, as the advisory opinion says, more potentially in terms of the kinds of issues which are dealt with by the Human Rights Committee and the International Committee on Economic, Social and Cultural Rights under the 1966 covenants. It will be a boon for the regional human rights institutions and supervisory bodies. It may make a difference in constitutional litigation. There's a case coming up in Canada where I can see it being very helpful. So I'm not sure that this is really going to shift as much as it could at the ILO in this political climate, but I think it might have implications elsewhere. On that issue about scope and content and whether that matters, I think what has happened at the ILO and elsewhere is with this challenge to whether the right to strike was itself even protected in line with freedom of association, the right to organize, is that apart from the Inter-American Court of Human Rights, which has been bold and very exciting, a lot of bodies have been quite cautious. And I have been part of a project that's been looking at reimagining the right to strike, which is a group of academics and activists from all over the world contributed to that 2026 book, which is open access online through Hart and Bloomsbury. So I'm not
We
even
will
trying to
throw
sell
a
the book.
link.
I'm just advertising it there as a
Yes,
resource for everybody.
we will throw a
And
link under the pod. Yes.
yeah, yeah, so it's open access. And the reason that we wanted to do that was we just wanted to stop being so defensive about the right to strike and just trying to defend its existence and instead get on to thinking about how do we modify our understandings of a right to strike to respond to global supply chains, to respond to newly digitized workplaces. What is a right to strike in the context of algorithmic management and artificial intelligence? What do we do to preserve that? How do we perhaps use strikes to address climate change, but not to create problems regarding emissions or environmental harms? How do we support the legitimacy of strikes to pursue democratic objectives, given the rise of extreme right-wing governments and autocratic government? So I think there's a good case for widening the scope of the right to strike. And a lot of us are starting to very actively make those cases. So I'm less worried about saying, I don't want the jurisprudence of the Committee of Experts or the Committee on Freedom of Association, the right to strike, to be preserved like museum pieces. I just like to see them as foundational and think about building on them. So scope and content, we'll keep on arguing about this and trying to push the agenda forwards rather than trying to just preserve what we've achieved so far, I think. Yeah.
No, that sounds to me perfectly persuasive, right? That people will be arguing from a different position and from a better argumentative, at least, if not political, given what you were saying, but at least in terms of argument and legal doctrine, it is a better argumentative position than the opposite, or
Mm.
than uncertainty. Fantastic. Thank you so much. You've been so generous with your knowledge and with your time. Thank you so much. Thanks to everyone for listening. And before actually, we have like a lighthearted question at the end, which is, it's summer is coming up at the south of the northern hemisphere, and my question is, which we often ask people, what do you do when you don't think about international labor law and, employers denying workers their basic right? Is there anything you enjoy doing to unwind?
Oh, yes. So, no, I mean, Bristol is a gorgeous city, has a really thriving kind of arts, cultural, political community, lots of drama. It also has a really impressive open air swimming lake, which is in an old quarry. So when the weather gets really hot here, it's beautiful to go and swim. And I actually live half an hour outside of Bristol at the start of the Wye Valley in Wales. So I go exploring castles with guests and Roman ruins. So, yes, so you should plan to visit and explore. Great place to visit. Yeah.
Gorgeous. Yes, I agree. And so is Wales.
Mm.
Okay, we finished with the best advertisement for your part of the world. Thank you so much for your time and yeah, for all the work you did for this case.